Hey guys, how's it going? Welcome back to the channel. My name is John, and today we're going to be going over the latest developments in the Scarlett Johansson versus Disney lawsuit. Hey guys, how's it going? Welcome back to the channel. Again, my name is John, and today we're going to be doing a breakdown of the latest developments in the Scarlett Johansson versus Disney lawsuit. I hope you'll subscribe to the channel as we go along this journey together of reacting to Marvel movies and Star Wars television shows and movies. And right now we're sitting at 222 subscribers, so help me get to that 225 subscriber mark. Only a couple to go. All right, so today we're going to be going over the latest developments in the Scarlett Johansson versus Disney lawsuit. I've done a previous full breakdown of the lawsuit, and I will make sure to put a link to that video in the description, but you can also find it on my channel. One of the interesting things over the weekend was that on Friday, Disney filed a motion to have the case decided by private arbitration. So what is the arbitration process? So arbitration is where you get a one or several individuals. It's a private process where you get these individuals or single person to decide the dispute amongst the disputing parties, much like a judge or a jury would, only it's generally one or several people and it's done in private. So why would Disney file this motion to have the case arbitrated? Well, really for two reasons. One is that it's a private process. It is something done in private so that none of the dirty laundry of either of the parties gets aired out into the open. And when you're a huge company like that, sometimes you have that benefit to where you won't want things that you do or processes that you have to make it out into the public. And so you typically will find this arbitration clause in a lot of contracts. But one of the reasons that Disney wanted to have it decided by arbitration is because it is private and nobody's dirty laundry will get aired out during this process. Two is that the arbitrator is oftentimes another attorney. The thinking here is that the arbitrator, the attorney, will be more analytical in its thinking when it comes to deciding the dispute. The arbitrator, if he was a lawyer, would be able to take into the legal arguments, not so much the emotional arguments of the case when it is presented to them. That is at least the argument that Disney would have in mind when they filed the motion, is that they could keep all of their acts in private, and two, that it's probably going to be decided by another lawyer. He would be much more analytical and less swayed by emotion to decide the case. So why would Johansson be against settling this dispute in arbitration? Well, for a couple of reasons. First, if the case is tried out in the open by a jury, then perhaps there might be some negative press for Disney and they might be more apt to settle. When things are done by a jury, as you all know, we've all seen the TV shows and the news channels where you see cases tried out by a jury, and sometimes things just aren't pretty. And so they're hopeful, I imagine, that the negative press that Disney would receive by having this all done out in the open would make them more apt to settle in the case, or at least paint Disney in a negative light in front of the jury. Second, as opposed to the case with the arbitrator, if the case is tried by a jury, they may be more swayed by emotion than necessarily the legal arguments that the parties make. Juries tend to take all of these factors into consideration, and that's why you always hear about the opening statements of the attorneys and the closing arguments of the attorneys having such a big impact on the jury, because this is their opportunity to just lay it all out on the line, and they can do so with their words and the way they say things so that they can perhaps sway the jury one way or the other, versus an arbitrator who's an attorney who may be less likely to do that. Now, in its motion, Disney argued that Johansson agreed in her contract that she would resolve all of her disputes by this arbitration. This is a very common clause that you'll find in a lot of contracts. It's mandatory arbitration. Companies tend to like that because it's usually cheaper, it's private, it's often done by an attorney. and they may be able to just lay out the legal arguments of their case, and the arbitrator may be much more analytical, as we've already discussed. But it's certainly cheaper, and it's done in private. And they argue that Johansson agreed to this in her contract. To the contrary, Johansson argues back that no, I don't have an agreement with you, Disney. I have an agreement with Marvel. Perhaps there's an agreement in there that Marvel and I settle these disputes by arbitration. There is no such agreement between you and I, Disney. And that is what she is saying, that it was Disney that interfered with this contractual relationship that she had with Marvel. It's really, really interesting, and it's going to be a very interesting case that has a lot of implications for the entertainment industry. But the most recent developments in this case is that Disney has filed a motion to have it decided by private arbitration, and Johansson, rightly so, her attorneys have argued, no, let's try it out in the open so that we can get all of this out in front of the jury and have a jury of 12 people decide what this case should be. So this arbitration issue should be resolved after an October 15th hearing in the case. I imagine on that day, the attorneys are going to argue whether it should go to arbitration or not. Then ultimately, the judge will decide whether it should or not. So that case, they're almost never decided at the hearing themselves. Usually, the judge will take it under consideration and decide it at a later date. So we suspect that it will be decided sometime after this October 15th hearing, where they should hear the arbitration issue. Now, Disney should be a little bit careful of what it wishes for. The attorney in this case, who's representing Scarlett Johansson, has some history in going into arbitration against entertainment companies. It wasn't too long ago that he was awarded a $178 million judgment against Fox for a case that he took to arbitration. So Disney might want to be a little bit careful about what they do in this case and the things that they ask for. Arbitration really worked out well for this attorney, but I imagine he would still want it to go to a jury so that it can be tried out there, just for it being out in the open and perhaps the negative press that Disney would receive, and the ability to sway the jury into perhaps an even larger judgment in this case. So we'll have to see how it turns out following this October 15th hearing. All right, so those are the latest developments in the Scarlett Johansson versus Disney lawsuit. The arbitration motion was filed on Friday, and so we should get some resolution to that in just a couple of months. So what do you think? Do you think that Scarlett is in the right here? Do you think she's in the wrong for bringing the lawsuit? What do you think about Disney streaming it on its service? Tell me what you think about them filing the motion to have it arbitrated so that everything will be kept private. Those are very interesting topics as this case moves along. Again, thank you for watching the video, and I hope you'll subscribe to the channel as we go along this journey together. And until we have some further developments in this case, or we watch another video together, I will see you then.